My name is Claire Overman. I am a media and information law barrister at Doughty Street Chambers, and this webinar will be covering recent case law developments in the law of defamation, and in particular, the requirement to show serious harm under Section 1 of the Defamation Act 2013. So I'll start just with a brief outline of the topics that I will be covering in this webinar. They are, firstly, what is the serious harm requirement in defamation law? So a reminder of the position prior to the Defamation Act 2013, and then a closer look at the changes that were brought in by that requirement. We'll look at the key case law that's developed since the 2013 Act on how the requirement operates in practice. And then we will take a look at some recent commentary in the cases in the last few years. So turning then first to the position prior to the Defamation Act 2013, at common law, a published statement about a person was actionable simply if it had a defamatory tendency. Now that meant that the court would look at the meaning of the statement complained of, with what's known as the single meaning that an ordinary reasonable reader would attribute to a statement complained of. The court would determine that single meaning, which is an exercise that it would carry out solely with reference to the words complained of. And it was an exercise governed by a series of well-established principles in the case law as to the attributes of such a reader. And then having done that, the court would consider whether that meaning that it had determined had a defamatory tendency. So what was required was that it attributed to a person behaviour or views that were contrary to the common shared views of society and would tend to have a substantially adverse effect on the way people would treat a person. So very much an exercise grounded in the meaning of the statement complained of. In terms of damage to a claimant's reputation, outside of certain very specific cases, so certain types of slander, so oral defamation, this would be presumed. So damage to reputation would generally be presumed. And so what this meant in practice was that a claimant could have a viable defamation claim without any examination of whether the publication had any real world effect on his or her reputation. So in that sense, a very favourable regime for claimants. There was nonetheless some protection for defendants in claims of a trivial nature. So, for example, where there had been very limited publication of even very serious statements. So in the first instance, when looking at the defamatory tendency of a statement,